Obi, me also me too catch it.
Enye easy. Na bibi aboko.
Me pato bibia yeboko. Apart from Putin or how you ask for again.
Yeah.
Bibia yeboko.
I can see that. Now, Enra mekai wo initial reaction to Supreme Court ruling, no, quite a detailed reaction, but essentially, no, now a point pa anything.
You Obi, yeah, and your decision. No. Number one, ye di hun koma, ye who judgment, no, into no, or say ye two year bo.
Ekosiisen
But
Asempa
still,
FM.
ye one more book decision the tougher my into no tougher no na ye bo hun komo yi. Ni keti ani mu ni say ye aban na ye wono ya chemu miensa. Eye one more yamra. One more amran ya ye no, one more beko implementing mrano. And one more the Intiasia ma one more extra embrano assist. One more extra embrano in judiciary. One more embrano in parliament. And now one more implementing embrano executive. Now that branches mean saying Obia ye equal, Obia ye independent. To some extent, no, one be the boom. But some essential pieces of our continuing country of our say, you say. Into offer court no who the case the qua a beer one more edgy judges
Ekosiisen
Asempa have in the case. When we then we judges five. One now we decided Parliament and to me for catch say we start this fight. And now who control opinion one. When we tini about say wo justice or say bonsu. What trust our opinion? Executive need to me come down. I don't know mama justice or say bonsu. I trust our opinion. Sasuna okay. Article 109. Article 109 said about 10 year parliament. Every year we make parliament. One more procedures, one more processes. No. Parliament now one standing order and for govern. It is based on standing orders. Parliament, we say that we are deputy speaker. Not all preside. No debate, untimi yedi. Eba vote na untimi vote bi. Na odwe ho a nyansa e wo saa we ni mu standing order because number one, it follows from the constitution. So who read the constitution it comes to the crowd one. You come to the conclusion that that's what the conclusion wants them to do. And number two, the who presided now to make us say Obi me ma on kasa Kwaku kasa we are out of order kwesi who had been my palm work because me ma on go to who disturb the house no call more or less no when you are presiding you elevate you above all the MPs to the extent say who fellow MP no put me working with fellow MP out. Ultimate catch your fellow MP so you're out of order. And anything other than one very respect, even though we know your MP. But for the time being now, presiding, they should accord you some deference and respect because of Sir Jumano and his position who occupy temporarily. They say no Supreme Court said lady who presiding
Ekosiisen
why you who say referee we about to offside we about to throw we about to say no one also no what utimi kobo ball libi into one presiding officer no utimi ka say me voice vote ye for no etiam a utimi tiam bi no for no etiam a utimi di uyi anu aka say ai ye for na me ka omo ho no ye ne awini
Asempa
o di ho a aya wan say judges in soon etimi trate conclude say this is what the Constitution wants, and this is what they are interpreting the Constitution. Political and parliamentary history. Speaker, the notion of speaker. Most of the speakers can now be a judge. From olden days, Judge Chris, Judge Akiwumi, Judge Griffiths Randolph, Justice Anna. The reason NCIS some most of them as judges, because you value the quality of impartiality. That is so fundamental with our system. There, to me, if you are the Supreme Court now, it's a big problem, a big issue. So that is my number one.
No, but on your number one, no, on your number one, no, Prof. Don't you also think, sir, a deputy speaker cannot be part of the debate? Said standing orders no and you refer to what the Constitution says, and it's on your many when that deputy speaker no a member of parliament, a man for atuaba voter, yen say a sacred. In a representative democracy, it was a man for representation in the Parliament of Ghana. The deputy speakership has additional responsibility. Nipane primary role in the chamber, and also about representing the constituent. Inti the mere fact about Parliament, what be additional responsibility inti that primary role of representation. No, what baby? Is that your argument?
Asempa FM.
No. And it is not my argument to say the primary role of representation of a parliament or that MP. You are looking at it from one end. But of this idea, which make us say who MP won't kasa, who MP will be kasa, it doesn't mean say, oh yes sir, not just the primary role we are bashing it. No. For a temporary period when he's presiding, he is not allowed to take part in the decisions of Parliament because of that way, And OSHA Article 1045, meaning say, who Constitution is that when
the Constitution was
Upa kind Article 1045 because and only another example.
Okay.
Of the member be.
And let me, my main kind of way about him. Or say a member who is a party to or a partner in a firm which is a party to a contract where the government shall declare his interest and shall not vote on any question relating to the contract.
Who declare interest? We are going to make us my declare interest. Now, more forget about me. Now, I'm representing for Baomi, Mumami vote. That is not the essence of representative way. There are many instances when, for one reason or the other, an MP will not vote. Like I said, the speaker or presiding. Otimi decided say a member is misbehaving and walk him out. And when he walks him out, as some member no own vote. Well, the rules allow that. If you misbehave now, the speaker can walk you out. And the notion of representation, it's not a savior for you. A lot of our MPs, are appointed as ministers. Most people don't realize that when they are appointed as ministers, most of their time, they are not going to be representing them. They are going to be working as ministers. But that is allowed. That doesn't take away from representative government. The whole UK system, all their or most of their parliamentarians are also ministers. But it doesn't mean that it takes away from representative government. And mind you, I'm someone who is very pro-representation. Into a parliament, I can say, I'm watching 2008, 2005, dispensation said, on tablet and solving drug problems. Ma in Kwaku seat, and unoccupied. I was one of the people at the court. I said, no, that cannot happen. Even Parliament cannot give an MP an indefinite dispensation to be absent from Parliament. And the court agreed with me. So, when it comes to representation, I'm one of the strongest advocates of that. But representation doesn't mean that all other values are suspended, because there are other important values that must be balanced. And in this case, one of the important values is the impartiality of the person presiding. And if you believe that occasionally, deputy speaker and a bit take you away from your primary role as an MP, don't even put yourself for to be elected as a deputy. Secondly, that is the reason why the Constitution itself says you have 2 deputies. One will see the same party. Into hardship now, spread out. And let's be clear, most of the time, speaker and so occasionally, when a deputy speaker is presiding, most of the time, what are they really deciding? Not, your motion is carried, this and that. It's just because this particular parliament is split. Yana Forecast is hung. Hung is the wrong word. It's split. Because it's split, we shouldn't be making terrible decisions that undermine our institutions. Impartiality of the presiding officer is an overriding value. Yet we should be defending at all times.
But and because and so say Prof, and because Parliament near split, when we know just one vote can tilt the balance of power in the House. And nuntina say Obi through no fault of his, a MP, now onya the additional responsibility to become a deputy speaker in a parliament like this. Because I get everything you've said so far, in an ideal situation, a parliament where there's a clear majority, but in a parliament like this, now one vote pet to me tilted the balance of power as far as decision making in the House is concerned. Now, many additional responsibility to be speaking here. You say, I should not be part of the voting to take a decision in the House. What would that also mean? Looking at the nature of the parliament is here.
It doesn't mean anything, and that's why I started by saying that's why the load is balanced, because the deputies should not come from the same party. So that one comes from here, the other comes from here. We can be alternating, and then the life of parliament is 4 years. We shouldn't destroy our values because 1 or 2 days some important decision or we are not even thinking about tomorrow. Let me give you an example of that type of thinking a higher in Ghana. Last year, one more can say for me now MP I am not doing so of next parliament about running as independent into was vacating the position as MP. When you you read the Constitution, the Constitution doesn't say that at all. They went ahead, vacated the position. Then when he won as independent, they say no about independence. Then the story has changed. Now they are saying that he can run again as another party. No country can be successful if it is run just like this, no principle. There has to be some principles. It doesn't matter the people involved, the issues, and so on. We must stand for values, for principles, for consistency. Everything I'm saying now, if you switch the parties, I'll still be saying the same thing. When I'm analyzing these issues, I close my eyes to the people involved. And sometimes I'm saying things that, maybe it goes against the people I support, but the truth must always be told. We must put our country above our party. We must put our principles above our politics. We must be honest when it comes to interpreting our fundamental documents. Say the constitutional politics are. Oh my God. And then ye diago. So I'm out for the almost say cool. No, soldier for pen cool. This modern era, no soldiers for cool. What you have no civilians.
Asempa
Our more violate the constitution in major ways, undermining the constitution itself. No, a form of a coup. This is what the Trump and his people did all the time, and ultimately, even when the election results came in, they decided that they are not going to accept that, leading to all kinds of problems in the United States. We have to be honest with ourselves.
Prof, in the now, what you were expecting, let's say?
In law, no, complicated case or cases make for bad law. Because you try to solve those complicated cases, or like you said, because it is hanged, and can't constitution, then hang, Where in the constitution does it say a demand of the deputy speaker to depend on the number of people or the number of. There's nothing like that. And we should interpret the constitution in that way without bending it.
And the now expectation is when the NIPA or their application is called Supreme Court, the Supreme Court should have declined jurisdiction on the matter. Say, where the men farmer ha yentiminka huasem. Sada na woshe.
Of course, because Ukai,
Ekosiisen
and I'm
on
sure
Asempa
their decision will probably even cite to four. Ghana, Obia Eka to four. One of the key propositions I want to form said the law of parliament, a different law by itself. The courts don't know anything about it. So when parliamentary issues arise, unless it clearly violates the constitution, for instance, I'm watching the Yakase MP and representing the constituencies or now the constituent. Now I'm watching Apatna America at that jail for a certain indefinite time I obeba. Parliament no munu enti say I'm watching is still an end. That one the court will come in. Incidentally, court also can say because of the importance of representation, if you are an MP, now we are absent from parliament for more than 15 sittings in a meeting, automatically I have vacated. You have a lot of people almost say representation who here, and there are people who are absent for more than 15 days. There is a court of judgment saying that the seat is automatically vacated. I know the constitution like I said, I know why? Because of opportunism. I know a behind the Ghana school. You hear and the quarry a war ya brabum. Sometimes you don't have the numbers. You don't have the numbers. Only numbers are and ya patapa. Nemo ni other people no chance to say, yeah, you know, say many numbers, many numbers. You know, Rodono, Yebechemufa, also Papa, Namisme Papa. Then we move on. But Okase, Ode Patapa, Ebe Ye Juma, Madame Kopina Kunoka say,
Ekosiisen
Emra,
Asempa
and Yadi Raw Bros. Or the Patapa Bros, Emra, and Yadi Raw. Now, the air who say, Emra Nankasa, ya Patapa Mla. Ochna constitution idea woman yemfa yebe can be beautiful for adentia oh no me see too tight nti o say can be beautiful
Prof, the other thing is contention back on is Sanka Supreme Court Nankasa application they should have declined said I mean parliamentary procedure anyone rules no. But when you look at even Article 110 of the Constitution, subject to the provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure. And that regulation, no, and laws are made to regulate their own procedure, no, should be subject to provisions of this Constitution. And I think Article 2:1 and so 2:1b Emma Supreme Court ne kwan say obi ehu say enactment bi anamra bi any constitution ebo ebra na omo de ba the Supreme Court can be called upon to deal with that particular issue aba before it. And I would even refer you to Speaker of Parliament Ankasa Alban Sumana Bagben. I think Otu kwan baako eba ya na decisions bi akoso won echi no obeye long statement bi say okaya paragraph 26 of that statement oka say by and large the reasoning of the first deputy speaker outlining the fact that he is not the speaker, he holds his membership and does not lose his privileges as a member when he takes the chair, can be said to be correct. However, insofar as he takes on the role as the acting Speaker of Parliament, his decision to be counted as part of the numbers forming a quorum raises procedural challenges. Or the Songhua, who was expected to deal with our procedural challenges, no, if not the Supreme Court?
Very, Obi, good question. Number one, Senior can say making standing orders, no, and yet subject to the Constitution itself, no. And no, none yet say Parliament, Mrabi, I mean, order be said, I'm watching can be out indefinitely. I went to court because in that case, no, Parliament exceeded its powers. That's what subject to the Constitution means. As long as you stay within the Constitution, then there is no way another party or another branch of government can come and tell you that do it otherwise. Number two, for you to say, sir, Parliament could not have done that, the Supreme Court requires a particular article that they can say, sir, article when it say, Parliament has violated that.
Okay.
There is no such article that anybody, including the court, can cite.
But you've not seen their detailed ruling. How do you come to that conclusion?
Well, I've read the Constitution 299 articles maybe 25 times. Maybe they've seen something that I've not seen. So I'll wait tomorrow. I take your word as good advice. Ochna, what me quote Bibia. But based on what I read, not just the Constitution, but the history, the constitutional history of this country, dating back to the Constituent Assembly reports and so on, that's what I'm talking about. Number two, jurisdiction. You raised the question of jurisdiction.
Yes.
So, OBDD call Article 2. Does it mean the court has to just immerse itself? No. The court has to first evaluate whether it has jurisdiction or whether its jurisdiction is properly invoked. And if it is not, then they cannot accept it. So in this case, no, even if they accept their jurisdiction is properly invoked, there is a common law doctrine, well known by the judges. It's called the political question doctrine.
Mm-hmm.
And that political question doctrine is the same thing that I've been talking about there. As long as Parliament has not violated the Constitution or any other law, then when it is operating its own processes now, no court can come in and tell them, say, well, the way, the way. Let me give you one example. One of the standing orders of Parliament, when they are in a committee, most of parliamentary work is done in the committee.
Yes.
Most of the representation is done in committee. There's a standing order, IHS said, we are committee chairperson, only vote. But when we vote a tire, you have a casting vote. Is the Supreme Court telling us that because of representation, that standing order is also unconstitutional? I mean, the King said the Supreme Court will become the senior prefect of Parliament, vetting every standing order that they do to see whether a consistent with representation is the most absurd thing that anybody can contemplate. Number three, let's understand that even Honorable Joe Owusu, or your deputy speaker, if you go back to his state, sir, he said, the fact that a deputy speaker cannot vote in Parliament is not something that is even subject to debate because everybody is aware of that. He said that. He knows that. He's a very good lawyer. And he was right when he was saying that. Number four,
yes.
Of the time, one of the important things that Speaker Bagbin did there, even though as a matter of principle, he disagrees with the ruling of the Speaker pro tempore, Joe, he also understands that when the deputy speaker or the speaker pro tempore presides now, he has the same powers as the speaker. And so he's not going to disturb that ruling. That's what Bagin said. And that's the importance of understanding the functions of the person who is presiding as the Speaker of the House. He has the same powers as the Speaker of the House, and every rule that applies to the Speaker applies to him as well.
Ekosiisen on Asempa FM.
The court is saying that somebody who is presiding can be a partisaner, then how do you expect the other members now? One more face, the Nipa no ti akonya nimu no ono obe our interest obe vote no or captain kasa. Why should I accept that? Or rule me point of order or rule tell me out of order? Why should I accept that? Why should I give deference to a person who has a vote when he's presiding? I said, Mokobobo, now you see, Obi free outside, Obi free penalty, Obi free win, or no, Sonia Bona, Otimi Boshe. Who would have said such person as the referee.
Yeah, I don't know if the
No, but-
football, me sure the football analogy, applies here because football,
It is-
no,
it is not- don't-
Prof,
Uh-huh.
football, no,
Okay.
the referee is not part of any of the teams. In this case, no, the deputy speaker is first a member of parliament. That should not be lost out on anybody. And the other question, and I'm person Mibusa, for the sake of time, Honorable Jogati Atnase. Now me person Mibusa say, Osha, what happened on the day? There was obviously a cul-de-sac. Now obia ehun babya. Or because na interpretations na kwa too. Speaker out here Germany say oh no ho kwan or kind constitution understanding of this na dwen chere say e beto aba. Some members on the minority free say enye sa na tie. In that cul-de-sac moment, no, who would have resolved the issues if not the Supreme Court? Because I remember at the time, na nkofo ka say oh yemfa nko Supreme Court na court na nkasa wo ho na obia enhu ni way clear. So why do you think the Supreme Court should have declined jurisdiction on such an important issue?
Because the Supreme Court is not a political entity. Merely because you have a political debate that is complicated, that is unresolved, that is messy and so on. I don't know if they should just come in and say, okay, we are going to decide it. That is the worst time to come in because you are taking sides in a political debate, and if you want a Supreme Court to lose its credibility, that's the easiest way to do it. But let me go back to the football analogy because you used to be as analogy. It doesn't mean say every point of the analogy should apply. Of course, in a football game, the players belong to a team. We all know that. But what we are saying is when somebody from the team is now appointed, say, for some period on your referee, then that person from the team cannot continue to play for his team while he's also being the referee.
Absolutely.
It's just a simple analogy. It shouldn't be taken so literally as to miss the analogy. The most important thing is we are saying that the person who is presiding should not have a vested interest in terms of how you vote and so on. Because the voice vote. Most of the decisions in parliament by
voice vote, yes.
Uno obey voice vote. Uno obey decide say yeah phone anya and no phone anya. But you already have said that would who shall party get? Who will take you seriously when you say the yes have it or the no have it? That's what we are talking about.
Inti na me busa say eba ne sa na ye hiti sa call the sack no anka parliament basically I resolve sa issue no.
Well, that's what I'm saying. Eventually, both sides in parliament, they will say, look, we have to sit down and start talking to each other. Because Obia ni numbers now, Obe pushing Ninyama through. It may take them a while, but that's part of them going up in politics. They will realize that you need numbers into your compromise. That is what we do. I mean, over US, they've done it so much. Over Senate, the Democrats would have 51 votes, and the Republicans have 49 votes. Sometimes 50-50, and then the vice president will have to come in to cast a vote when there's a tie. When you have that type of split parliament now, you cannot just say, I'm going to have my way, and you just talk. No, it won't work. Or say they forget about the old parliament now. The OPB no matter. Okay, you can say you policy way. You 100. Also say you 0. Me is 50. Now you can't wait. Give and take. Who the give and take? No, that is how.
But with the entrenched positions we saw in parliament, who proposal they are say too idealistic.
Because then I can say eventually, both sides the rule said entrenchment is not leading to anywhere, then you will start compromising. Right now, no, people have the hope and maybe the illusion that they still can get their way through, and so they are pausing. Eventually, you know, everybody will wake up and they will understand, say, hey, when we are 137 and yes, we are 137, and yeah, they basically push your way through. Into the entrance, some of the times we will get some of the things we want. They will also get some of the things they want, and maybe the country may even be better off because of the compromises. Because instead of just talking, nobody listening. Now we'll get to a point where when one person talks, the other person will listen. When one person gives, the other person will take, and through that back and forth, and the on mine one a two porno.
Okay. Prof, I wish we had enough time to get into some of the other issues, but I'll let you go after this message. Krobia Asante comes through. I say, Obi, in Canada, the Speaker of the House of Commons is an elected MP. He or she does not vote on decisions unless there is a tie, i.e. a casting vote. This is so because he is an MP. In Ghana, the Speaker of Parliament has no vote, be it original or casting vote, because he is not an MP. Why should a Deputy Speaker not vote in Ghana when he is an MP? Isn't this $1 million absurdity from proponent like Prof? Again, in Australia, the Speaker of the House, who is also an MP, votes in committee of the whole, but does not participate in standing committee proceedings. Prof, what's the question? No, any input? No.
But the question, no, but your answer to our question, I mean, all these examples from Canada, Australia, and so on are irrelevant. We have our own laws, and we should concentrate on what our laws say. I've already explained to you, say, in our laws, no, okay, Article 1045. Anytime you share them out, Article 105, no, because it was just one instance. Obia or representing constituency. Yeah, money go to because of a conflict of interest, and that's why I said that there is a balancing of value. Of course, the deputy speaker votes in most of the cases. Mm-hmm. We are only talking about a particularized situation when he is also presiding as your friend is saying, as the speaker. As the speaker. Furthermore, we have a lot of ministers who cannot just make it to parliament some of the time, if not most of the time, merely because they are ministers and cannot come to that doesn't mean that they devalue representation. That's just a very simplistic understanding of what representation is all about and what voting is all about and what is the basis of, in some cases, not allowing some people to vote. I've even given you the example there. Somebody who is acting as a speaker can say that who will be here in parliament
into walkout
out of order, so I'm walking you out, and after that they will vote without you. You have no cause at law to say that I was representing my people and I've been denied my vote. Why was I kicked out? The parliament itself has standing orders. They have processes that allow the smooth running of parliament.
Very well.
And we cannot just continue to say that, represent you, deputy speaker, Kranoa, also voting. That is completely wrong. And if you, one last point, if you read the one, I think it's Article 1025 or something, I can't remember the exact one. They even talk about when you talk about a quorum, say the quorum is a certain percentage. I think it's 1/3.
No, quorum 102. 1/3 of all members of parliament, apart from the person presiding.
Apart from the person presiding, and apart from the speakers who, even a regular, like if the deputy speaker is not there and the speaker is not there, and the House itself temporarily elects somebody to go and preside, that person is not even counted as part of the quorum. Now, if you are not counted as part of the quorum, how much more to take part in the debate and then to go and vote? Come on, and your money do so simple, say.
Okay. Prof, Mamenase, Bibiania will come back to you. Lawyer Jogate Ewaha, and I hope you would listen to him. Bibiania, the conversation will continue. Why?
Ojo.
In the hotel, yes,
Prof, Munia.
Yes.
But the good thing about law and lawyers in there, we can agree to disagree.
Agree to disagree, that's true.
Cape Coast, I'm
Okay.
a young lawyer.
Okay.
Then that time, they believe more. Many are him for be. Him for Omahin and Nudom, Ogumechi, the Cape Coast High Court, so all my do day. It's like an amphitheater.
Yes.
Ne Makasawi and Mamu and Makasa Mikita Magown. Ne other lawyer, shed at the situation boy, Bruna Kata, different suit, different as the Musha James are in view. Ne Paddy Oshas or Casa, Mura. Nevi Paddy cases MUC or use the same cases. Oh no, man, better interpretation than I gave it. It's only maybe the Mr. Demite Paddy. Don't argue with and a judging, and I won't carry one can. And I said, Mr. Gatti, so what should we do? I argue. Paddy, so argue. Maybe Sunday, what should we do here? It's all them rule.
Yes.
As I said, Mr. Gatti, what should we do? I said, my lord, I'll withdraw my application. I said, that's the most sensible thing for you to have done. Application struck out as withdrawn. No orders to cause. Next case. It's a big client are confused. I said, quickly, judging, in whom we'll see. Yeah, 2 man. It's before we be some. That was to me so judging say, it was that. Oh, the way we can register. More can obey file in there. Cape Coast one. It's a before file more. That's the beauty. Because I disagree with everything Prof said.
Yeah.
And
you do?
Oh, everything he said, I disagree with him. Totally.
Not even when he asked, sir, what part of the standing orders and a contravening any provision in the Constitution?
I disagree with him. First of all,